approval. Now, in talking with planning staff and considering this matter and looking at it up and down and every which way, and the threats of litigation, the noticing concerns are very serious. And in fact, you know, the Art Center has made the appropriate request to the county to review this matter and take action to undo what it improperly did on the 15th. It is also our further recommendation, and I strongly recommend this for all parties involved, that the board renotice this matter in accordance with the law and allow this board to rehear the entire application with all potential options identified for consideration. And I also can't emphasize enough that we have to have proper noticing of matters that are come before the public. I mean, that's just germane to what we do here. The public needs to be fully aware and fully informed of all possible options and considerations. I also need to state that we do need to get this plan review done, and it is long overdue, and it's my recommendation that we need to move forward to accomplish this. And that may be a discussion for another day, but I can't emphasize that enough. So unless staff has anything else to add to that, that's the basis for my recommendation. And you can hear from the public, and you can ask me questions, and we can move forward.
If we don't have any questions or comments from the boards, we're going to go out to the public for public comment. First up, Jared Carter.
Thank you, Mr. Chairman, members of the board. I hope you have a letter that I sent to you yesterday. I had very little time to review this matter and get it done, but I hand-delivered it over here, and I see from Supervisor Brown that you do. So I'm not going to repeat that. There are just a few points I want to make. One, I don't think the matter is appropriate even to be here today. The way I read your rules, without the affirmative vote of Supervisor Pinches, no matter for rescission or reconsideration can be brought to this board. And it's my understanding from my letter from County Council that Supervisor Pinches has not voted affirmatively to be here, and without his affirmative vote, it is my belief that there is nothing that this board can do on this subject. That's what your rules provide. That's what the general law provides. I cited you a couple of cases to that effect. Now, in my letter, what I've pointed out is that when you try to take away a property right from somebody, that's pretty serious stuff, and you subject not only the county but yourselves to the risk of litigation and personal liability. I don't want to threaten you people. I don't want to sue your people. My client wants to live in peace with you. But my clients have, since the action on the 15th, conducted his business in accordance with that resolution, and he continues to do that and will continue to do that until and unless there's a final court order somewhere that says he's got to stop. What I want you to think about, ever since I started practice, when a client comes into my office and says, here are the facts, and by gosh, we're going to go to court and win them, I tell them there are 4 sets of facts in everything I've ever done. There's what my client thinks. There's what the opponent thinks. There is the truth written in the sky somewhere. And there's what the trier of fact, once you have a lawsuit, thinks. And the only one that matters is what the trier of fact in the lawsuit thinks. And we're not going to know that for 2 years. A jury, probably in Oakland, will decide that question if a civil rights action is brought. Because the Del Monte Dunes case by the U.S. Supreme Court says that these are questions of fact that'll be decided by a jury. And what we've got, you all sat through, not all of you. I don't think that Supervisor Brown was here, but and maybe Supervisor McCowan was in the audience. But they're on tape, the vituperative, disputive hearing that was conducted, the allegations made against my client intemperately, and I'm sure Mr. Colfax is sorry for the intemperance now, but all of those facts are there and will be viewed by a jury. So you folks, before you take another action of questionable legality to take away a right my client has, need to think about whether you want to subject yourself to that process. And my recommendation is that you not do it, because I personally believe my clients will win that lawsuit. But what I think, and what county council thinks, and what any other lawyer here may tell you is not going to control that. We won't know that answer till all of the discovery is done about who had what notice, who had what information, who made what points, what telephone calls were made to what people. All of that will be developed and presented to a jury, and the question will be whether by taking action now, you're doing something right to resurrect some problem that was created, or whether you're doing something wrong to take away a property right, as I say you will be doing. And I think it would be a big mistake if you're going to contemplate that. As I said in my letter, if I were in your position, I'd want to go get some independent counsel from somebody that's not involved in this process to review the whole thing and give me some advice. Because remember this, almost every lawsuit that has ever been brought against a city or a county or a city or a county employee under the Federal Civil Rights Act, there has been a government counsel legal opinion saying what they were doing was okay. That's what public lawyers are hired to do, is advise their employers on whether what they want to do is okay. And they generally say it is. I generally tell my clients what they want to do is okay. So the fact that your county council says that something's okay doesn't make it okay. And if you take action to take away my client's rights now, I believe it's risky. I want to get along with you folks, but I need to tell you that, and I need to tell you there's a lot of money involved. And the other side of the coin that I point out is the Art Center isn't hurt. You can give the Art Center, when this review process is completed, all the spaces they can ever need. Nothing keeps you from doing it. And my clients are acting in accordance with the law. They pay their bed tax. They're conducting their business in accordance with the resolution that this board adopted. And to try to take that away from them will hurt them economically. They don't have any choice but to fight to keep what they've got. Be happy to try to answer any questions you have, but what I think on the merits of this, I emphasize, is not going to control. It's what a judge and a jury is going to think considerably down the line after we're all better informed on both the facts and the law. Thank you very much.
Thank you. Donald